$1,000 over the top to win out all of these multiple offer bids, things like that, and any advice that she could give us. So Nancy, I'm going to turn to you.
Okay. Great.
Yeah.
Good morning, everybody. I'm going to put on I have a PowerPoint. So we'll go through this and then I've got some other things I'll show you. So we'll get this on here and share that. And actually we'll start it there. So, okay. So just so you know, we've moved. I've actually merged my practice with Mike Rakowski, and we have a new office on Cayuga Road, Suite 150. It's right in front of the FedEx office. Actually behind me is FedEx. And just so you know where it is. So just wanted to share that with you. Okay, you know, this is really about how to maximize your chances in this crazy market. And, you know, I see agents doing all kinds of things. I have people calling me every day asking questions on what we can do. And what really scares me is waiving home inspections. That is an extremely frightening prospect for our purchasers. It's dangerous for them. And to be honest, it's dangerous for you. When things go wrong, they're always looking for someone to blame. And already I've had 3 or 4 clients who have called back and suggested that perhaps they should be suing their agent or even the listing agent because they didn't have a home inspection. And, you know, I don't know, I explain to people, if you're waiving a home inspection, that you're buying it as is, and that means whatever's there, all of its defects, and it's your responsibility to figure out what's an acceptable condition and what's not. But when things go wrong and they get a $15,000 bill for some basement work or for drainage work, they're looking to blame someone. So be really careful about saying that people shouldn't have a home inspection. And I know what you say. You say if you have a home inspection, you probably won't get the deal. But the purchasers interpret that as saying that my agent told me not to have a home inspection. And
Nancy, can I ask a question?
Sure.
What is your advice on home inspection for informational purposes? Still doing the home inspection? Are we still covering ourselves?
No, well, you know, you got to be really careful with that, Luke. As long as you say it's for informational purposes only, however, purchaser retains the right to cancel this contract. So I have to put that in every time you write for informational purposes only, because in my mind, and as a strict constructionist, which is what a court would do, they would say, that's it, you're having a home inspection, but nothing on that home inspection can be used for any purpose. You can't cancel the contract. And we, of course, our buyers all want to be able to cancel the contract if it goes badly, right? Why else would you have it? So make sure you write that on there. You can say it's for informational purposes only. However, you know, comma, however, the purchaser retains the right to cancel this contract under paragraph 9. That's what I usually write. And then that way your buyer knows that this is not a situation where they can negotiate, but at least they have the right to cancel if it goes badly. And you know what happens too is sometimes you find something wrong in a home inspection and a seller's going to say, let's negotiate that. You know, I don't want you to cancel. I didn't know that I had a leaky roof. Let me fix that. So I think that's, I don't mind that language. You just have to be sure that you add additionally that the purchaser continues to have the right to cancel under paragraph 9. Okay. I've also seen people pre-inspecting. And that's what I've seen a lot of lately, and mostly from my clients who have had multiple offers lost. And when they find a house that they like before the offers are due, they'll have someone come in, not a full home inspection. So they're not checking every outlet. They know that there are things that might be wrong, but they're doing the major components. They're doing the basement, they're doing electrical, they're doing plumbing, and they're looking at the roof and windows, you know, just kind of a quick one. Someone told me the other day that no home inspector would do it. I don't know, I've had multiple home inspectors do it. They just probably don't have a limited services contract available, but that's what I've had happen. So, you know, I just worry about your liability if there's no home inspection. I talk to my clients every single time they waive a home inspection about it. Remember, you can't go back after someone, but when, like I said, when things go wrong, they're looking for someone to blame. And that's what I'm afraid is going to happen next year, is we'll have all the blame coming out. Okay, another important aspect to maximizing your chances in this crazy market is to make sure that your contracts are perfect. And the reason is, if you write, Luke, like if you were going to write just that the home inspection is for informational purposes only, I have to add, however, we still retain the right to cancel under paragraph 9. And the moment I add something, that becomes a conditional attorney approval. And whenever there's a conditional attorney approval, the other side can cancel the contract, no matter how minor it is, they can cancel without any notice whatsoever. So I don't want to have to fix contracts. I do, but I don't want to have to fix them because that creates the ability of the other side to disapprove. And why are they disapproving? They're disapproving because they get another offer in the meantime, right? That's what's happening. So during the time that I'm reviewing a contract, somebody else comes in and says, I've got a better offer, it's $10,000 more. And the seller side is looking for a way out. So they have the ability to disapprove. So we want to make sure our contracts are perfect. Double check them, fill in all the blanks, even if it's with an NA, think about the blanks and think about what you've written. And I'm going to help you with some language today, but think about what you've written on those things. When I find something wrong with the contract, what we're doing now, and this is incredible amounts of work for us, but it's the way we have to do it, is we're creating an addendum immediately and getting it to the agents before my attorney approval period is up. So I can get a signed addendum fixing any issues before my attorney approval is up, so I can give an unconditional attorney approval. So, just things we have to think about. If there's something wrong, let's get an addendum too and do it. In the same vein, or on that same line of thinking, make sure you check the seller's name and you use the correct terminology in your contracts. So know who is selling. If someone has died, if the owner has died, it's the estate of whoever died. You can also write by whoever is executor, but you don't need to. The estate of Mary A. Smith is sufficient. If somebody's signing as power of attorney for Mary, it's Mary who's selling by the power of attorney. I've given you language for the trust. And the last one is really important too. You have to look at the deed for the seller. If the mother or dad says, hey, we own this house, but we gave it to our children, the children also have to sign, and as does the parent, if they've reserved a life estate. So Mary's the life tenant and the children are the remaindermen. And that's the language. If you can eliminate the life tenant and the remainderment as long as you name them all as sellers, because it's really important. Otherwise, you may be missing one of the sellers from your contract. I don't know if you know these clauses. Can anybody, just by show of hands or whatever, do you use the Instinet transaction desk system clauses? Yes, okay, you do. That's good. These are attorney drafted, and that means Nancy Saia drafted, just so you know. And so there's language in there that you can use. You don't have to reinvent the wheel. So there are clauses for replacement housing contingency and its release, post-closing occupancy, seller date changes, all of that. And I've got the list there, but this is the replacement housing contingency language. Just so it's there. All you have to do is select it, and it goes into an addendum or paragraph 20 and fill in the date and you're good to go. If you don't know how to use these, please ask us, please ask Amy, use them all. This is the post-closing occupancy language. Just when you see this language, there's some of it in brackets. You see the bracketed language. So that means there's an either or. You either set rent or you can do the 1/30th of the PITI, just pick one and remove the brackets, of course. And this allows you also to set the amount of the security deposit. Somebody had a question, I think, and Eric sent me some questions. If the client's not paying rent, I assume you must disclose it. You can simply put it here when you do post-closing occupancy. And if a seller is, I guess, if they're staying in post-closing occupancy, you can just say that the rent is zero. That's what's happening in this market. And one of the things that purchasers can do to maximize their chances to get the deal, if a seller has to stay in, perhaps you give a favorable rent. Why not? You know, it costs a little bit of money, but most of that is interest on your mortgage payment, which is deductible anyway. So, you know, it might be a way for your deal to be selected. I'm going to go back. I'm going to stop share. Let's see. I'm going to stop sharing for a minute, and I'm going to share a different screen for you. Let's see if I've got it up. Sorry about that. Hang on. Municipal code of addendum. Okay, here it is.
And while Nancy's getting the other screen, just so you guys know, when you do the clauses, there's a little search bar. So like if I'm looking for the escalation clause, I just write an escalation and it pops up automatically. So, because there's a lot of clauses in that little, in the clause section. So if you just type in a keyword, what you're looking for, it'll automatically pop up.
Okay, great. Yes. And I can't see if you can see what, do you see the addendum system database clauses? Is that up? Okay. So this is all of them. And I emailed this list to Eric so he can forward the list to everyone so you can print them out and have them with you or keep it on your desktop or your laptop.
I got them, Nance.
They're all, yeah, I emailed them out this morning, so y'all have them.
Perfect. So, you know, so if you're looking for something, you can easily scroll and see, oh, that's in there, I can take it. And even if you're not, if you're doing a contract or an addendum and you've got to do it by hand, at least the language is here for you. Okay, so, you know, something to look at when you want to. Whoops. Do we close my?
Do contracts by hand?
People do. I know. Am I sharing or did I lose my sharing now?
You lost it.
Really? Okay. All right. Was it back?
Now, yes, now it's working.
All right, good. Okay, no idea why. All right, so let's see. I want everybody to also think carefully about the dates in the contracts. You know, again, we tell people that the dates are target dates and we kind of pick them out of the air. Don't. I mean, don't do that. Pick dates that make sense. Think about them. Talk about the dates because, again, we don't want to have to change them. And we also don't want a deadline to pass that gives the seller the right to cancel the contract. So the one that happens most often and lately has been used by people to cancel contracts by sellers is that a purchaser didn't receive and accept the mortgage commitment by the deadline in paragraph 12, 10b3. So if we don't, there's no notice that is required to be given. And the seller can just cancel and move on to that next deal. So we don't want that to happen. The other one that I've seen used a lot lately by sellers is the failure to deliver the deposit in time. And again, these are without notice. If you fail to meet those deadlines, the seller can cancel and that's it, you're done. And you've lost the opportunity to buy something that you thought you were buying. So look at those, pick dates that make sense and closing dates as well. You know, just make sure you've had a conversation about it in advance.
Nancy, before you go on to the next one, I had a question that I saw on one of our realtor Facebook pages yesterday from a buyer's agent that said that the purchaser or the buyer's agent does not have to give the listing agent or the other side a copy of their commitment letter. Is that?
No, it's in the contract. You have to give a full copy.
Okay.
It's in the contract. It's in paragraph.
But they said we have to give it to the seller's attorney, not the seller's agent or office.
Well, that's true. I mean, the contract says it has to be provided to the, let's see, do I have a contract? I will tell you exactly what it says, what the language is right now. I think it says to the, actually, I think it says to the other side, to the other party. Deliver to the seller's attorneys and the brokers.
Oh.
It does say that. So look in paragraph 10B, 4B. So on page 5, it's under the cooperation section. Purchaser authorizes and agrees.
Are you gonna call her out, Eric, and tell her she's wrong?
Deliver a complete copy.
I'd like to, but I don't think it's the aggravation. But I
No.
just wanted to double check. I thought that was not correct. So
There it is. I didn't even realize it said for the broker. So it's in there. So you're protected. One of the other things that's happening a lot is these appraisal issues. Okay. And whoops, I don't want to do that. And everything's going over asking, right? So I just had this conversation with clients yesterday. So their house was listed at 169, their offer is 210, and they want to be protected if the appraisal comes in at 169. And I said, well, you know, you offered more to get this deal. Yeah, we did. We offered more. We want to make sure we get the deal. And I said, well, okay, if you've done that, you know that you're offering more than the house is worth. Why are you not obligated to pay 210 in all circumstances? And they were kind of shocked because they thought, well, if it doesn't appraise, you know, we get to pay what the appraisal value is. I said, that's not true at all. It's all, you only get to adjust the price or cancel really because of an appraisal in the event that the appraisal affects your ability to borrow the money that you've said you're going to borrow in paragraph 10, okay? So if you are only borrowing 80% of the purchase price and the appraisal does not affect the amount that you can borrow and you can be approved to borrow that amount, then it doesn't matter and you can't do anything. You can't cancel, you can't ask to renegotiate. Now, if you're borrowing 95% or 97%, obviously a change in the appraisal will affect the percentage of the purchase price that you can borrow. So, you know, it kind of depends on what the contract says. But people have this wrong notion that the appraisal protects the purchaser. It does not. It's merely for the lender and to give the lender an idea of how much they should lend. So in many circumstances, it does not affect the loan that the purchaser is getting, and that is of no consequence. I'm not sure people know that. I'm not sure sellers know that. I'm not sure that every agent knows that. And I'm not sure that every attorney knows that. So we've been going through all these gyrations of various kinds of appraisal clauses. This is one that I have on there. I'm going to stop the screen share and do another screen share. Let's see if I can, this comes up now. Let's see. Eric, I just sent you these and I don't know if anybody else saw those. I just sent them this morning. So Annette at Benar asked me to write language for these appraisal issues. And I wrote these and then passed them around to my attorney friends to see if we could give them to Benar. And they said no. They didn't want to have this language out there for agents to use without their input. Well, it's the Wild West out there. Nobody's checking with an attorney before they draft this language anyway. So I'm sharing it with you. So there are, what do we have here? 5 different options based on, who you represent in this deal and what the concept is and what do we want to do. The last one is basically, hey, we'll pay X number of dollars above the appraisal up to the purchase price, but no less than some number. And if it's less than that number, either party can cancel. But there are different options there. The language is not, it can always be adjusted if you need to, but at least there are options that you can discuss with your clients, your purchasers and your sellers and see which one works, okay? And there's no magic to any of this language, but at least it has various options for you that are more complete than the ones I've seen being drafted and bandied about. I think this is a little bit better for you. So you've got some other options if you need it. Okay. All right. Go back to that screen share again. Sorry. This takes a lot to do. All right. There we go. Let's see. Just want to make sure I got the right one. Okay. Writing the PINA carefully. Think about those PINAs all the time. I'm constantly having to deal with air conditioning and pools this time of year, and I shouldn't because I shouldn't be making attorney approval conditions. But air conditioning can't be tested today. Maybe later in the week it can be tested, but right now it can't be tested. So that should be on a PINA. And if a purchaser is not having a home inspection, put that in paragraph 20 because you have to protect your purchasers. Make sure that the air conditioning is in working order. So we've waived the home inspection, but we want to make sure that it's in working order because we can't test it. We don't know if the air conditioning works. And the same thing with the pool or a sprinkler system or anything else that is seasonal. Okay. When you're writing the PINA and something does have to be repaired, try to write out the repairs in detail. And I suggest even attaching the estimate for the work that's going to be done. So remember that the PINA starts with, the seller shall, and then so you can start with the action verb, have a licensed electrician replace the, service panel or something like that. Or have, Joe's electrical service replace the service panel according to the attached estimate. What happens a lot with PINAs is that there are differing expectations. Okay, sellers thinking I'm doing the cheapest thing possible, and purchasers thinking this is going to be repaired and be fantastic. And very often one party is very disappointed in what happens with the PINA repairs. So I've got one right now where the PINA says that the seller is going to install a wall-mounted heat source. Okay, what does that mean? A wall-mounted heat source. So we've gone back and said it has to be satisfactory to the purchaser. It has to be sufficient to be the sole heating source for the entire upstairs. So that's what we've been negotiating. And the seller says, well, before we, figure that out, let me show you what I'm going to buy. And what they're buying are on clearance from Wayfair. These little, they're almost fake fireplaces, and they want to put 2 of those in there. Well, I think the BTUs that are coming off of these things, I think my computer gives off more heat. They're not heat sources. They're decorative. But the seller thinks that he's getting away with 2 $95 units when my clients are thinking that, this is going to be a $3,000 heat source. So we're far away, and, the PINA needs to be drafted and crafted. And I think that that's an important word, craft that PINA sufficiently so that it encompasses what the parties expect, at least what the purchaser expects, and do the homework to get it done and put in whatever estimates or whatever it is that you're anticipating. In this case, the agents didn't anticipate and they needed to, so we're working on that. But you want to keep your deal going. This is the way to make sure that you're detailed in what you present. Also, always follow up on the PINA repairs. Make sure they're getting done as you go along. It's ridiculous. Again, just by example, I have another one that I was dealing with before we started the Zoom conference. Is the seller was supposed to have some chimney work done. Well, nobody was available. They couldn't get it done. We're getting closer to closing, and seller says, well, let's just escrow for it. Well, the lender won't let you escrow for PINA repairs. It's very difficult to get a lender to escrow for PINA repairs these days. They want everything completed. They don't want to wait on this, and they don't care. The weather's fine. You can do chimney work. So we're going to be delayed on this closing. Follow up on mortgage conditions. When you get the commitment, take a look at it. Is it subject to the sale of any property that wasn't disclosed in the contract, or subject to a gift that wasn't disclosed in the contract? And deal with those conditions immediately, because a commitment is not a commitment by the terms of the contract if there are conditions that were not disclosed in the contract. So if the commitment comes out subject to the closing of a particular piece of property for the purchaser, and our loan commitment due date has passed, seller can cancel. You didn't get a commitment by the defined term of what a commitment is in time. You're done, you're out. I'm selling to the next guy who's going to give me 10 grand more. Okay, so jump on that. Make sure that your loan officers know that there's, even though the purchaser is selling a property, that there's no contingency and it cannot be in the commitment. Also, help by following up on any remaining contract issues. Anything that's out there that needs to be taken care of that hasn't been, follow up on that. Make sure that everything, sometimes there are additional contingencies, just follow up. Make sure your purchasers have their money in place. Be ready even before they start going out shopping for a house. They should have their money in a local bank so they can get official checks for closing. You know, I think people don't realize that these days we're running into a lot of people who have just internet banking, nothing else. Well, you know, how do you get an official check from your internet bank? You know, just FYI, you can't. There's no way to get it. Sometimes they'll send it to a local bank, but mostly that would be a commercial bank, probably like a city bank. We don't have any city banks locally, so you can't get official checks for them. People who have their banking in Rochester, we get figures the day before closing, if we're lucky. Sometimes the morning of closing, we will get the figures. And now the purchasers have to find a way to get official checks for the closing. And sometimes that's impossible. So, you know, just something to have people ready for. If they don't have a local bank and they don't wish to open a local bank, then what we have them do is wire the money to us, to our trust account a couple of days in advance. But we need to know that. I mean, you know, the other thing is we put all of this in an engagement letter to our clients. I spent a lot of time making sure that our engagement letters are complete and accurate and, you know, all inclusive, and nobody reads them. So that's the problem. Nobody reads anything you send them. In fact, and they'll argue with me that you never told me this, and I will highlight the sections in the letter, and then they'll come back and say, but I don't read that. Well, what can I do? So, you know, if they are internet bankers or they're coming into town and they're not planning on opening a local bank account, we need to know that. And it's just something to think of. So I think what we'll do, I know you had some other questions, or there's something else I wanted to show you. Hang on a minute. Let's see, I'm going to do this again. I don't know why. Oh, escalation provision. Eric had a question about the escalation provision too. Again, I wrote this and sent it to the my bar group to say, hey, you know, there's a lot of escalations going on. You know, can we come up with something that makes sense so we can deal with this issue? And they said no. So I get a lot of pushback from lawyers too, just so you know. But I have this language, and it is at least a little bit more extensive on what can be done for escalations. And I know that they're out there, and I hate them. I don't know if you hate them. My answer is always just give me your best offer, and I'm not going to allow you to escalate. If you think you can pay up to $270, but you're offering $230 with various escalations, then offer me $270.
Nancy, why do you hate them? Just because you just like the best and final, or is there another reason?
No, sure.
I think they're great, but
I don't think there's a meeting of the minds, Luke. I think that if this were challenged in court, it would fail. What's the price? Okay, I mean, that's the simple, you know, you took contracts, you all took a course in contracts. When you make an offer, what's your price? There is no defined price. You can't tell me what the price is. You can't tell me what this offer is, because it doesn't have a value. And so I don't think there's a meeting of the mind. I think legally it fails. I don't know if anybody's ever challenged it. I've never found a case on it. But I think if somebody wanted to challenge it, they could. And I have to tell you that lawyers everywhere agree on that. I've given some of the escalation clauses to some litigators in town, and they are chomping at the bit to sue one of these, because it's absolutely contracts 101. There's no meeting of the minds. What's the price? You have no price. So I think as a sales tool, it works well. I think legally it fails.
okay.
And so what I've attempted to do within this rider is to try to at least fix some of the flaws in the escalation provisions that are commonly out there. But still, initially, I think it fails legally. So it's a very good question. I think as a marketing tool, it works great. But I think that legally, it's not a contract.
And Nancy, I like it for my buyers. I don't like it for my sellers.
Sure.
I was
Very
thinking the same
difficult.
thing. I feel like it would work better for people who are buying. And it's like one of those really rare occasion ones too. I feel like not many people know about it a lot too. So it's usually only if somebody actually knows about it.
And then, you know, you're one of the questions that Eric sent is, you know, what happens how do you handle multiple escalations? Well, these clauses that are out there are not very well written. So they don't, they're not written by lawyers, and, we're trained to think what if in every circumstance. You read every word, every piece of punctuation, a comma makes a huge difference in what something means. And, so we're trained in doing that. Obviously you guys are trained in other more important skills, but not trained in drafting language. And so I see these escalation clauses all the time, and I'm not sure what they mean. I can't tell you. And even if I ask the person who drafted it what it means, I don't think that's what it says. So, the whole idea of this one is that at some point, if there is an escalation, and it talks about, is there one or multiple successive up to, or, not to exceed the maximum purchase price. But the real key thing is that you have to sign a contract that then removes the escalation clause, because that's the other problem, is it stays in the contract. There's nothing in the ones that you guys are drafting that says this escalation has ended. You should do an addendum that says the escalation clause is deleted and the purchase price is hereby amended to read. And then you have a final purchase price and it's over. Because, the language is just not, it doesn't say whether or not there are multiple escalations or successive escalations that are allowed. So, this was my attempt at it. I've been using it. Actually, this has been around. I've had this for probably 5 or 6 years, to be honest. We've used it successfully. I just don't like them because of the fact that there is, even with this, there is no meeting of the minds until you do the final addendum. So, and then
would it be easy, instead of doing an addendum with the final price, would it just be easier to just draw a new contract with the new price?
Sure, you can do it that way. You can do it that way. It doesn't matter. Either way works. And your question, one of the other questions you sent me is what happens if it's a VA or an FHA offer? And that has to do with the appraisal issue. I'm sorry, I'm going to jump back to the appraisal issue because I wanted to finish that thought too. If it's a VA or an FHA and all that language about paying more than the appraisal, you can't undermine that. So the FHA and the VA give a buyer an automatic right to cancel the contract if the property does not appraise. And, I don't know because it's not been litigated. I don't know if I say in a contract that I'll pay more than the appraised value, I'll pay $5,000 more than the appraised value, if that undermines my right with the loan, but I don't think so. I think the loan would be canceled. So I don't think that a buyer can agree to change the FHA or VA rules. So be careful about that. That's a problem. I'm just trying to see if there are any other questions in Eric's email to me. Oh, I think I got it. I think I've got those. All right, I'm gonna stop sharing and see if you have any more questions. Anybody have any questions?
How can it be possible that no one's got a question for Nancy?
I do, of course.
Sure.
So my two bosses, Bob and Judy, I'll say no. We were talking a little bit about transfer tax.
Okay.
And who is it split? Can it be the seller? So I'll just quickly, for sale by owner, I'm representing the purchaser.
Okay.
And their mortgage company asked if they are splitting the transfer tax or if the seller is paying it.
Okay.
Do you know my question then? Because I don't really know what it is.
Sure. So our contract, there are two transfer tax that mortgage companies think of when they think of transfer tax. We call the seller's part transfer tax, and we call the purchaser's part mortgage tax. But national lenders call it all transfer tax. So there are two different parts of that. And it's not that it's split, it's just that each of them pays their own share. So the seller's transfer tax is $9 per thousand of the sales price set by New York law. unless they're over 62 and it's their principal residence, that is $4 per thousand. But $9 per thousand. So $100,000 house, $900, that's what the seller pays. That is what we call transfer tax. And that's the seller's share. The purchaser pays a mortgage tax based on the amount that they're borrowing. 0.75% of the mortgage, and then they subtract $25. So if you're getting a $100,000 mortgage, 3/4 of that is $750, and they subtract $25, $725. That's the purchaser's share. So they're different, but national lenders don't do that, and they don't read our contracts, so they don't have an idea of who pays what. So when they disclose on the loan estimate, they disclose to the purchaser both of those combined, which makes no sense, and it's very confusing. And so, your purchasers just kind of need to know that there's a part of that. All the purchasers are paying under our contract in terms of transfer tax, when it says it on the loan estimate, is 0.75% of the mortgage, less $25.
Okay, because that's where, okay, now you explained it, because I didn't ask the question correctly. So that's what I was getting confused with, because when the bank is coming and asking me how we're doing it, I've never been asked that before. So I didn't know, and I didn't know the difference. He was calling it all transfer tax, but I did know about the mortgage tax, but I didn't know if they were, I didn't realize they were maybe calling transfer tax all one entity, I guess.
You would have no way of knowing that. There's no way of you to know that.
All right.
It's just what they do. I've looked at so many loan estimates, and what I tell people is, when you're looking at your loan estimate, I mean, it's really difficult, because the whole idea of the loan estimate, right, is to tell the purchaser what they're going to need for closing.
Right.
Well, they're like almost always wrong. So how do people know? I actually tell my folks, send me the loan estimate. I'll take a look at it. I'm going to tell you what's right. I'm going to tell you what's wrong, and I'll give you your figures. I'll correct them. But it's usually, that's one that happens all the time.
Okay.
It's very often that the lenders who aren't familiar with our local market, even some who do work in our local market, don't know that the transfer tax that we used to call it deed stamps. Bob and Judy would remember deed stamps.
Oh, yeah.
And they were literally stamps that they would stick to the bottom of a deed. And now it's, so just so you know, $9 per thousand. In Erie County, Niagara County is $4 per thousand. Erie County is the only one locally that's $9 per thousand. The other counties are $4 per thousand. And the mortgage tax is always 0.75% less $25.
So I just have to worry about the mortgage tax. So I can just respond back to this banker and be like, we're just covering the mortgage tax.
Correct.
And then we're not splitting the transfer tax.
That is all seller.
Okay, all
But
right.
in their parlance, it's all transfer tax anyway. They may not know the mortgage tax. I mean, some of these loan officers honestly don't know what the mortgage tax is in our county. So just remind them,
Okay.
0.75%.
Thank you.
Yeah, easy.
And Nancy, you can speak to this. We are seeing, and I've heard that in order to try to get an offer, some buyers are actually willing to pay for the seller's transfer tax along with the search and survey. What else are you seeing that's kind of wild and wacky that are getting people deals that we may not have covered?
Free rent, a lot of times free rent for post-closing occupancy, all kinds of flexibility on closing dates for sellers and vacancy dates, all of that. Search and survey starting to happen, that the purchaser is paying for the search and the purchaser is paying for the survey. I've not seen a transfer tax one. That's a big amount. I suppose, I don't know why you would do that and just not increase the price. I can't think of a reason that makes sense. You can just simply do that. But if it's going to make a difference, in a search and a survey, just so you know, the expense of that survey is about $500 these days. And a search can be anywhere from, and the cost of a search depends on how long of a period of time they have to search. The search company has to search. So if the seller just bought the house 2 years ago, a couple $100. If they can't find their search, and we're going back to 1920, which is what our standard says, is that if you can't find a search, you start in 1920, you're looking at $1,000. So it can be, $1,500 if for a purchaser in that circumstance, if they're paying for the search and survey.
So if you're putting that in your contract, would you be putting that in as like an addendum or in just like in
Paragraph 20.
section?
Yeah, paragraph 20, purchaser shall pay for the cost of the updated or the search and the survey. And they are defined terms, so you can just use a capital S for search and a capital S for survey. And, you know, and that's an important thing to do whenever you're doing an addendum or you're filling in paragraph 20. Know that there are defined terms, the word contract, purchaser, seller, they're defined terms. And so you should use a capital letter to start off all of them, because that means that you're using the term that's defined. If you use property with a small p, it doesn't mean the property in the contract with a capital P. So, you know those terms and use them. And it's easy. You don't have to say this contract, you can say the contract. You know, and it's always with capital C, and you know, you don't have to refer to anything else.
I have another question.
Sure.
I just had this happen today. I've been waiting for is the attorney approval for a house, and they totally bypassed me and just sent it over to the attorney. Is that customary, or I don't know why they're not?
Approval?
Yeah, why aren't they copying the agent on it, or is that?
Oh,
really
they should. Yeah, I would
Okay.
think.
All right, I thought so, and I told the attorney that, and I said, oh, I'm usually copied on all that stuff, and he said, well, you're gonna have to call your attorney.
That's weird.
Okay.
Yeah,
All
I
right.
don't know. That just sounds like laziness to me.
Well, yeah, I mean, some people just are jerks just to be jerks.
Yeah, I think so. They are out there. I saw a question from Brad, why do we need a search from 1920? And I'll answer that question. So about 1920, so our searches, we're really lucky in Western New York. Most of our searches go back to the Holland Land Company, which is in the early 1800s. So we have this incredible history. But Buffalo was a very vibrant city. And the suburbs, the first suburban sprawl started around 1920. And the reason our searches start in 1920 is because that's when easements started to go in place and restrictive covenants. Easements are the right of someone else to use your land for a particular purpose. And there are easements everywhere. So where my old office was in the North Cheektowaga Snyder area, there happens to be a 1928, I think, water line easement that runs through Saratoga and Mount Vernon and those streets. And it is actually under 3 or 4 houses, which is a problem for those 3 or 4 houses. But we need to know where those easements are. We need to know that the easements exist, and those easements are everywhere. And they started around the 1920s is when they first started. And so you need to know where those lines exist. Is your house on top of the water line? Is the pool that you're planning on top of the water line? That will be a very nasty surprise, won't it? So those water lines exist, power lines exist. There are gas transmission lines as we are going further out into Clarence and Newstead and all of these other places. There are some very old gas transmission lines that still in play. And when you're not buying in a subdivision, you're just buying one lot. You don't know what's out there. Maybe in the subdivision there's much more research that's done. But in a particular standalone lot, you may find that those gas transmission lines are in your backyard. And if we don't have a search that goes back far enough to tell us that, we've got a problem. And I had one of those, I think it was out at Thompson Road. And a client was buying and she wanted to add on big, enormous house that was already built, but she wanted to add on. And so we were able to find an easement. I didn't represent her actually I was representing her and she was buying. She wanted to add on for this house. And we were able to find the easement, and the easement to high pressure 24-inch gas transmission lines in her backyard. And one was just off where the garage was currently built. I mean, literally probably 10 feet away. And any addition that she would have done, probably would have exploded. So she ended up not buying that property, but we need to know where those easements are, and as well, restrictive covenants. So various subdivisions were created starting around that time, and there are restrictions that are still in force. And actually, there are restrictive covenants in the city of Buffalo that predate 1920 If you're buying a house in the Depew Avenue area, there are restrictive covenants that go back to 1898 that are not only still in force, but they still have a committee that enforces those rules on what you can and cannot do to your home in that area. And so it's important. And if I ever, I represent anybody who's buying in that area, I make sure that the search goes back further because I know that those restrictive covenants are out there. So it's the only way we know, it's the only way we protect people. And somebody who's planning on tearing down one of those houses and changing the architecture and making it a more modern structure is simply not allowed. And you will not serve your client well if you don't remind them of those restrictive covenants.
Nancy, I was hoping you could talk to the states. We're doing more, listings, and I have a scenario. I think I actually talked to you about it, but I'd like you to go over with the group. We have a family that the brother died, did not have a will, and the attorney has not provided any documentation as far as putting the house on the market. So, I naturally have questions who's legally can do it. So what is the actual process of somebody passing, no will? How do we get the house on the market?
So whether they have a will or not, frankly, does not matter. I just spent an hour yesterday trying to explain this to a client, and it's hard to believe that it's this complicated, but it is. So if someone dies with a will or without a will, and the house was in their name alone, the only way that the house can be sold is if someone is legally appointed by surrogate's court to act instead of the person who has died as either executor, that means there was a will, or administrator if there was no will. So it's just a different set of forms that you file, but still somebody has to be appointed by surrogate's court. And you think, well, that's easy. There's no will or there is a will. The will says who gets to be executor. And if there is no will, New York law says there's a hierarchy of who can be an administrator. You go to spouse, children, and if there are no children, you go to grandchildren, then you go sideways, aunts and uncles and things like that. So there's a whole hierarchy of who can act as administrator. Once you find who can act as administrator, then you file the paperwork. But filing the paperwork for either an administration or a probate is complex, to say the least. So what you have to prove it's a petition, it's called a petition. You have to prove who the family members are of that person, even if they have a will, which most people find extraordinary. So if I have a will and it says I leave everything to my dear friend Amy Winkelhofer and her brother Eric Winkelhofer. Oh, well, there we go. I'm sorry, Luke. Yeah, sorry about that. Bob and Judy are going to be upset. But if it says that I'm leaving everything to Eric and Amy, and why would anybody else need to be involved? But the answer is that when we file the petition, even with my will, the petition has to show everybody who would inherit my estate if I didn't have a will. That's called the laws of intestacy. You either die testate with a will or intestate without a will. Makes no sense. Why does the in mean with, but it does, or without. So if I died intestate, you have to name everybody who would inherit if you didn't have a will. And there are rules for that too. So you have to go, they're called your distributees. So it's spouse and children if you have spouse and children. If you don't have children, but just a spouse, it's just your spouse. If you have children and no spouse, it's just your children. But let's say you have no spouse and no children. Okay, what happens then? Then it goes to parents. If you don't have parents, brothers and sisters. Don't have brothers and sisters, are there any nieces and nephews? Did you have any brothers or sisters who died before you and left children? Then it would name those people. But if you have no spouse, no children, your parents have predeceased, and you have no brothers and sisters left, other than my husband, that's me. I don't have any children of my own. I have a stepdaughter, but she doesn't count legally.
Can Mavis get it?
Yeah, well, this is interesting. So it goes to aunts and uncles. Well, I don't have any aunts and uncles alive. So when I die, I have to file a petition and I have to name and put the addresses for my 35 first cousins. I have 35 first cousins, and some of them have died leaving children. I haven't met some of these people. I don't know. I haven't met some of my cousins' children. I don't know them. They're, all over the country. But when I die, if Al predeceases me, I have to file a petition that names all of these people. And all of those people have to sign a waiver saying that my will, before Eric and Amy get everything, this is going to be a pain for you. Maybe I shouldn't name you. But before anybody in my will gets anything, all of these 35 first cousins have to sign a waiver. I mean, it's ridiculous. How much time is that going to take? So I'm spending all my money. That's my plan. But
So Nance, do Eric and I have to come in and mom and dad change our will to put all of our first cousins down to say?
No, because, well, you will have a similar problem. Well, you've got at least you'll have, if something happened to Eric, you have Jake. So
Eric's
that's
gonna get the pillow someday, so.
Yeah. So, it's really difficult, but I'm just saying, just as an example, mine is such a complicated one. So I use it as an example all the time, that some estates can be complicated. And so anybody who is what we call a distributee, who would inherit if you didn't have a will, that's the definition of a distributee, somebody who would, according to the laws of the state of New York, inherit if there was no will, has to be given notice. They get a copy of the will, and then they have to sign off on it saying, I don't object. Same thing if there is no will, that they would just inherit, but they still have to sign off. Well, that, you can imagine, can be a tedious process, okay? But let's say we get all these people and they sign everything they're supposed to sign, and then we take those papers and we file them in surrogate's court because we're ready. Or maybe you've got children and that's easy enough, or you've got a spouse and your spouse lives, it's easy enough to file the papers. We get to surrogate's court. Surrogate's court is telling us now they're so far behind. COVID made it worse, but they're so understaffed. They're telling us that when we file papers, don't even email them for 45 days, because 45 days, they won't be doing anything on your papers. So they sit there for 45 days until they can get to it, and then we can start bugging them. So their typical turnaround right now is probably 8 to 9 weeks to get probate documents approved. And that's if you.
And we can't list the house until we get approved by probate.
Yes, that was a long story, wasn't it? But that's exactly it. You cannot list until the court has named either the administrator or the executor.
So it could be an easy, at least 3 months or so from the time.
Sure, easy 3 months. Easy.
So the house is just sitting vacant, the family members probably have to pay the mortgage.
Yep. So what they need to do is see a lawyer immediately when the person dies to get the estate part of it moving along. So while they're cleaning out the house, have them get the estate part moving along
What a
as
nightmare.
quickly as possible. It's a nightmare. And surrogate's court is only going to get further behind. I mean, they were working part-time. I'm not sure they're even all back. In fact, they're not all back yet. They're still mostly working at home. So imagine, we send documents in. Actually, everything's electronic. And then, it gets sent to somebody's home where they're working on it, whatever, and they're all bogged down. And court cases are so far behind that they're trying to catch up on the court matters, the ones that have Zoom conference court appearances. So they can't get to the simple stuff.
So the moral is don't die anytime soon.
Correct. Don't die this year. Put it
Sounds
up.
good.
Get your act together
Yeah, knock on wood.
so we can get it all.
Anything else?
Anybody have any other questions?
Nancy, you could adopt me.
Okay, yeah.
I was just gonna say that.
I've known her
also have a
longer.
useless 16-year-old that can be adopted too.
He doesn't golf though, Nancy.
Oh, that won't work. You gotta go.
I'll start.
He'll start. Okay, that's good.
Anybody have anything else for Nance? I'm sure she.
No.
I have a sidebar question. I'm my dad's power of attorney, and so is my sister. We're closing on his property this week, and I can't find the original power of attorney. I do have a copy of it. Do I get that recertified? Because now my dad can't make sound decisions.
Was it filed? Was it recorded?
It was not.
Uh-oh, you're in big trouble.
I know. I don't know how to proceed.
Did the attorney who prepared the power of attorney, do they have the original?
No.
Oh, that is not a good answer. Your power of attorney is ineffective if you can't find the original. So the original needs to be recorded. And if you don't have an original, it's useless. And now
Okay.
you're going to some sort of other proceeding. So a conservatorship, it's not that anymore. It's a guardianship, I'm sorry. So, which is very expensive, time consuming.
That website that you mentioned to me a while back that you guys have access to, would that be something that you could look up to see if it actually did get filed and she doesn't know?
Sure. Sure. We could, if you want, just email me Dad's. If you have a copy, email me the copy.
Okay.
And I can at least check the county clerk's website and see if it was recorded.
Okay.
You don't know. And the attorney who did it, did they tell you did they give you the original? They give it to your dad?
They gave me the original and my children have taken over my office, so I can't locate it at this time. Yeah.
I think we need a scavenger hunt.
Yes, we're doing that.
Yes, there needs to be a big reward for whoever finds it.
Correct. Thank you.
Bob and Judy, call Nancy.
And your new office is beautiful. We were there yesterday for a refinance and it's gorgeous.
Oh, thank you. Thank you. It's really nice. But, I want to tell you, you really need to find that power of attorney because a guardianship proceeding will easily cost 20 grand.
Okay.
Yeah, it's not fun.
Good luck, Aaron.
Yeah.
Thanks. I'll find it.
Okay. Bob and Judy, call Nancy. Get that.
Yeah. We'll get them going.
Yeah,
Let's
Eric
make
or
that
I
our
can be in
summer
charge. I
project.
don't care which one.
We'll make that our summer project.
Yes. Anybody else have anything for Nance?
All right. And if something comes up and you want to ask me privately, don't hesitate. Shoot me an email, give me a call. Sometimes an email is a little bit easier so that I can be prepared and get whatever I need for you or look something up if I need to look it up. But I'm here all the time.
Nancy, why don't you pub where your new location is?
Yep, it's 303 Cayuga, Suite 150. So it is right on Cayuga, right in front of the FedEx office. So behind me, if I lift the screen, which I didn't want you to see because it's bright out there, but there's FedEx. Wrong way. There's FedEx. So the next time you drop something off at FedEx, it's right there. I watch the airplanes take off. And it's great. And, the office is it's huge. It's brand new. We've got lots of people here, so we're happy to help.
And you're
I
gonna.
have to memorize a new address. I know 1925 Kensington.
I know, 303 Cayuga, 150.
Well, thank you so much, Nancy. We always appreciate all your hard work and your advice, and you've taken care of at least the Winkelhofer family since I think I was born. We appreciate you and wish you all the best in your new office.
Thank you guys. I appreciate it. Amy, you've
Thank
just
you.
let everybody know I'm old. So
All right, maybe not since I was born. Definitely high school.
If it makes you feel better, I didn't think you were that old.
thank you. Way to go. I like him.
Zach, she's not adopting you.
Oh, come on, guys. I'm the youngest, though.
I already put claims on the adoption.
I played golf, dang it.
Youngest, everybody.
Oh, dang
you,
it. No
Nancy.
way. Okay, hold on. How old
Yeah,
are
but
you?
thank you so much.
All
I
right.
know you're busy. We're going to let you go.
All right. Thanks, guys.
Stick
Thanks,
around for a minute
right,
before we close this out.
Okay. Bye.
All right, guys, that was an hour. We're not going to really keep you much longer unless anyone has any questions for any of the Winks or any of the admins.
I just have a couple of quick announcements from the board. We've had a couple of meetings this week. The Beaner new website will look to be started at the end of June this year. From government affairs, please make sure you have all your fair housing ducks in a row. They actually have money set aside for testers. They're out there, they're calling, they're stopping in offices. So even for your clients that have tenants, you have to treat everybody exactly the same. If you do that with applications and even with qualifying anything, everybody has to be treated the same and you won't have a problem. for RPAC, we talk about RPAC, and that's our fund for politics for New York State. And
National, Erica, it's the Realtor Political Action Committee.
well, you should have gotten an email the other day that there's a bill going to be going up that they want to add 55 cents to a gallon of gas, and it's also going to be added to our gas for our homes. So it's very important that you keep an eye on that. They will keep us posted on it, but we're very opposed to that bill going forward because it's going to hurt our business and home ownership. And then lastly, and this is a big one, is there is a new Authentisign makeover. If you're not reading your messages of the day, please make sure that you do. When you go on to Authentisign, just kind of like how Facebook and some of the others had their classic views, when you go on to Authentisign, you're going to see two buttons at the top, and one says classic, one says new version, I think it's 2.0. And it's going to be up for a little while, and all of a sudden it's going to be gone. And you have to go on and play with it, make up a fictitious buyer or seller, and follow the steps. It's supposed to be very nice. I've only seen very little of it yet, but it is out there right now. It's supposed to be much, much faster. All the forms are right there, but please make sure that you review it, because once the cutoff's happening, and if you have to have a contract done, you're going to be in trouble. So please review. Okay. Other than that, that's about we have from Beaner.
Anybody have any questions for us?
I think it should be good.
Everybody? Oops, sorry, Zach, go ahead.
Oh, no, I think that should be good.
Okay.
Zach,
All right.
when you're done, call me, please.
All right, sounds good, man.
All right, well then everybody have a wonderful day. Get your butts out there, go sell, sell, sell. We appreciate all your hard work. And if you need us, you know where we are.